1A is where you and your spouse, you guys get together and you figure out how are we going to divide the assets? What are we going to do about the kids? What are we going to do about the house?
If we have the marital home, how do you cut that in half? Like if I don't have the money to buy out my partner, the unsaid part of your answer is if the judge can smell it, they're going to punish you for it, right?
Oh, yeah, definitely.
Yeah. What's the first thing you'd do if you were getting divorced tomorrow? I don't know who wrote these questions, by the way. You got to talk to the producer about this one. Welcome to Boston Barristers. I'm Chris O'Brien. I'm here today with my co-host Matthew Peterson. We're both practicing divorce attorneys here in Massachusetts, and we know firsthand from our time in the courts that going through a divorce can feel overwhelming, especially when you're trying to navigate our state's unique laws and procedures. So today we're going to take a look at some of the most common questions we get asked about Massachusetts divorce law. We'll break down the basics in plain English, no legal jargon if we can avoid it, no complicated theories, just practical answers to the questions that keep you up at night when you're going through this difficult process. We'll cover everything we can, from the grounds for divorce to our state's unique approach to property division, to child custody decisions and how the 2012 Alimony Reform Act changed the game for spousal support. We'll also talk about timelines, costs, and some of the special circumstances that can complicate your case. Before we dive in, let's be clear. Every divorce is different, and this podcast does not replace personalized legal advice. What we can do is give you the knowledge you need to have better conversations with your attorney and make more informed decisions about your future. So let's get started. Matthew, welcome. Why don't you start by introducing yourself to anybody who's listening? Tell them why they should take your advice, if we can call it. How long have you been practicing divorce law in Massachusetts?
First, how's it going, Chris? It's a rainy day in Massachusetts. It feels like every day when we record it is.
A beautiful day in New England. Spring, rainy, overcast, gray. Haven't seen the sun in a day and a half, but shouldn't complain because we have the opportunity to take some time out of our busy schedules and talk about a subject that's near and dear to both of us, which is the practice of law, specifically the challenges of navigating family court. So
definitely. So I've been doing divorces for about 6 years in Massachusetts, and I mean the biggest thing is that we've actually tried divorce cases. We fought these divorce cases. I mean, I've talked to people who've been practicing a lot longer who never tried a divorce. I mean, I'm in the middle of one right now. So yeah, I mean, definitely something that is a difficult subject, but we hope we can kind of navigate it, help people navigate it.
Yeah, I mean, you said you're in a divorce trial. I think you were like last week even. It was spent like most of the day in family court on a single day of trial, right?
Yeah, so and it's continuing on this coming up week too.
That's, I think, something that's unique, and we may get to it, but it's one of the things that's sort of surprising about divorce, even to people who are familiar with trial work, is that the trials can be continued for a long time, right? So we not only have to deal with the fact that the judges will want to push any sort of determination they have to make all the way to trial, but then the trial can take, what's the longest you've ever seen one go for?
Oh my gosh. I mean, I just finished one that I think the divorce trial started 2 years prior.
Yeah, that's what I'm talking about.
We had 5
people, but yeah.
Yeah. It's not like you see on TV where, even like Karen Reed, where it's a, 8-9 week divorce or 9-week trial. Here it's, you started on one day, you'll continue it 2 months later, you'll continue it again 3 months later. All of that. It depends on the attorney's schedule, judge's schedule, things like that. But yeah, let's dive in, man.
Sure. So, I mean, one of the first things I want to get out of the way is if someone is thinking about getting divorced, but they know that their spouse isn't going to want to go forward with the divorce, can they still get a divorce if it's not agreed to? And what does that even look like?
And Massachusetts is a no-fault state. And if your spouse doesn't want to get divorced, it's not an option to say, Judge, I'm asking you not to divorce us. The judge has to divorce people if one side wants it. I mean, it may take longer, it may be a lot more expensive if the other side doesn't want to cooperate, but even if your spouse doesn't want to get divorced, they can't stop it.
Now, you said no legal jargon, or maybe I said no legal jargon. What is a no fault? So now I'm going to have to be on the lookout for any legal jargon that comes our way. I know no fault's not one of those like Latin legalese things, but it's still something that people may not immediately know what it means to be a no fault divorce state. What does that mean?
So yeah, I mean, in the olden days, basically, you would have to have some reason to get divorced. You'd have to have some justification, infidelity among them, like things like that you would have to show is a reason for divorce. In Massachusetts, and I think in almost every state, you can have a no-fault divorce, which means that it's just an irretrievable breakdown of the marriage. It's not one side's fault or the other. And pretty much, I feel like it's been that for a very long time all around the country.
So you kind of touched on another topic I wanted to bring up, which is like the grounds for divorce. And it seems like what you're saying is in Massachusetts, you could basically got this catch-all, which is irretrievable breakdown, right? But then are there other grounds for divorce? Are there, it's sort of unnecessary if you can just sort of go right back to the irretrievable breakdown as a catch-all provision?
So I would say probably 95% of divorces are no fault or irretrievable breakdown. I mean, there are some uncommon areas like abuse, infidelity, inability to have children, things like that are technically still on the books as a reason for divorce, but it's not something that's necessary or something you have to prove.
So if it's not necessary, it's not something you have to prove. Is there anything to be gained by doing that? Or, is it just sort of change the way a judge might look at the case when it goes to trial?
I would say that probably it's very rare for somebody to file a divorce as something other than an irretrievable breakdown. That's a very aggressive step that a lot of people just find this not necessary. It makes the whole process even more emotional and contentious than it really needs to be.
So then what is, I know that we're going to have to explain some terms, just airdrop them in. What's the difference between a 1A divorce and a 1B divorce?
So a 1A divorce is an agreed upon divorce. It's where both parties file a joint petition. It's sometimes called an uncontested divorce. 1A is where you and your spouse, you guys get together and you figure out how are we going to divide the assets? What are we going to do about the kids? What are we going to do about the house? Retirement accounts, all of that kind of thing, alimony, child support. And you come to an agreement and you present it to the judge. It's the quickest way to get divorced in Massachusetts. Usually, depending on the court, you can get divorced in a couple of months, not counting the Nisi period, which the Nisi is a Latin word, but it's unfortunately one that we have to use.
Well, you can't just drop it in the middle of the podcast, Matthew. You got to tell people what. All right, first spell it if you can. We'll put you on the spot with that one.
Oh my gosh. Nisi. Nisi. A divorce Nisi. So okay. It's where the judge orders you divorce, but there's a period after that where the divorce is not finalized and you can't get remarried. I was actually in divorce court the other day and somebody said, "Oh, you mean I can't get married for this whole period?" And it's like, he just wanted to jump right back in it.
Okay. Undeterred by the tragedy of divorce court. Very well.
So the Nisi period is 90 days. Basically, after you go to court and the judge says, "Hey, you guys are divorced," you go your separate ways, you get an order that says 90 days from now, it'll become final. And you can't get remarried during that time. So a 1B divorce is where you file it contested. So only one side files a petition for divorce. The other side receives it and files an answer. And the big difference between them is that you don't have an agreement with the other side going into it. And
so it may not be, sorry, I want to make sure I clarify here. It's not necessarily that that the other side doesn't want to give you the divorce. It's that there is no agreement as to some of the details about it.
Exactly. So yeah, you don't have an agreement in place. You file for the divorce. And the big thing about it is that statutorily you can't get divorced for 6 months after you file a 1B divorce. So that means that even if you file a 1B divorce and your spouse says, "Hey, I agree, let's hammer this out," you still have to wait 6 months.
Now, is that 6 months before the process can begin or before a judge can basically sign off on the divorce?
Before the judge can sign off on the divorce.
Okay.
So even if you guys come to an agreement within that 6 month period, you have to wait 6 months to actually finalize the divorce in Massachusetts.
Do you have a sense for how uncommon a 1A divorce is? Because that sounds like the cleanest and probably what you would consider to be ideal for a person who wants to get divorced. But if there's not going to be one, even if you have somebody agreeing with you, if you don't have 100% agreement on everything else, you're switching into 1B now. So how uncommon is 1A? Do you have a sense?
I don't have a sense of, I don't have the numbers in front of me, obviously, to say how many divorces are filed 1A versus 1B. I can tell you that sitting in divorce court, it feels like a good half of them are 1A divorces where the judge just says, okay, you guys come to this agreement. Great job. You guys are divorced now. Here's the divorce order that you guys agreed to. But they may not be actually representative. And 1A is what you want to try to do. You want to try to hammer out the details. Even if you have your own lawyer, even if they have their own lawyer to advise you, you want to try to hammer it out before you go into the process and file a 1B divorce, because it just is so much cleaner, so much better than having a stranger in a black robe decide your kid's future.
So actually, that was backing up a minute. There's going to be my question is, if you have a 1A on your hands, not you, but a person who's looking at getting divorced, do you need a lawyer? What's the benefit? Can you just do this yourself?
So I've seen a lot of people that go in and try to do it themselves and they mess up the paperwork somehow, and they go in there and the judge says, no, actually you need this thing, actually you need that thing. And it ends up taking a little bit longer. And the other part about having a lawyer is a lawyer can tell you, hey, here's what you're giving up by agreeing to this. So you may think, oh, well, I don't want alimony from my spouse, but you may be entitled to alimony based on the law. So a lawyer will be able to tell you, hey, here are your different options when it comes to the divorce. Here, even if you eventually do come to an agreement, it's good to at least consult with somebody to tell you, here's what you're giving up by signing this agreement in particular.
Yeah, I can actually throw in just 2 cents from my own experience, which is that, I've seen clients who got divorced over a decade ago, and there's a component in the 1A divorce agreement that is now up to dispute. And there's some question as to how it should be resolved. And there's going to be contempt allegations flying around. And it's, you may have agreed at the time because you just wanted to be out of each other's hair. But now there's this lingering issue that hasn't been resolved yet. And now there's money on the line. And the single problem for that, the specific ones I'm thinking of is that the provision is not clear. And now you got to go back up in front of a judge and say, well, back in 2011, we meant this to say blank. And the judge is like, well, it doesn't seem to be what it says. And it's like, who wrote this? It's like, well, I did. It's like, okay, well, here's the problem with the way that you wrote it. And that's, I guess the benefits of having a lawyer would be somebody who can kind of button it up for you so that your interests are protected in the future. Because you may think it's over, but maybe it's not quite over if there are lingering obligations. So speaking of stuff, because it actually is a good segue to what the next issue, because the marital property, right? This has got to be one of the, other than children, this has got to be one of the biggest things people fight over in divorce, right? What can you tell us about divisions of marital property? Who gets what? Is it 50-50 straight down the middle? How does this normally work out?
So I always say that one of the big jobs in a divorce is putting all the marital property into a bucket and figuring out how to divide that bucket, right? So one of the things might be if you had pre-existing assets, and that may not be considered marital property. So if I had a house going into the marriage, I get married, that house doesn't all of a sudden become marital property. But Massachusetts has a very liberal definition of marital property here, where it can include pretty much anything in the divorce. So if I, using the example I just had, if I had a house that I brought into the marriage, but then it increased in value during the marriage, or we did improvements on it during the marriage, then that improvements and that increase in value is considered a marital asset. So even if the equity prior isn't, the equity during the marriage is. So even if people tell me all the time, well, I'm the only one that worked. It's in my name. That car is in my name. It doesn't matter whose name it's in. Your name could be on the deed to the house and your spouse's name could not be. Doesn't matter. That could be considered marital property. Same thing with cars, things like that. And also retirement accounts is another big one. So generally what you do is you look at, I'm trying not to use legal jargon here and just say what they are, but so you look at what the value of your retirement account was at the time of the marriage and how much it's grown since then. And that growth is a marital asset too. But pretty much anything. I mean, even like patents can be considered a marital asset. And things like that, and it doesn't matter whose name it's in. It doesn't matter who produced it. If it happened during the marriage, it's a marital asset.
Okay. And you can see how, one of the things I know that I've seen is it's as complicated as you can possibly imagine, right? Because you'll have circumstances or scenarios where, someone moves in with their new spouse into, a beautiful, well-appointed home, but then the spouse loses their job. And now the mortgage is being paid only by the person who just came into it. So who gets what? And it really becomes, in some ways a really big math problem, right? Like it's not simply a matter of who gets the dog. And on Tuesdays, it's like, we really have to hash out the value of this thing and on a certain timeline. So
yeah, I mean, I always think about there's this old meme where a couple in the 90s was dividing their Beanie Baby collection under court supervision. And you see these two adults with lawyers sitting at the counsel table, a judge sitting up there, and they're picking Beanie Babies one by one out of their collection. I just can't imagine how much they paid those lawyers to sit there and how worthless that Beanie Baby collection is now. But
I mean, it's worth more than my Dutch tulip collection, I'll tell you that much. So
today's episode is brought to you by the Law Office of Matthew W. Peterson. If you're facing legal trouble in Massachusetts, whether it's an OUI, a firearm charge, or even just a clerk magistrate hearing, the stakes couldn't be higher. This isn't the time to go at it alone. You need more than just a lawyer. You need a legal team that knows how to fight and knows how to win. That's why people across Massachusetts turn to the Law Office of Matthew W. Peterson. With years of experience in criminal defense, family law, and immigration, we've got the track record and the passion to defend your rights. We've successfully represented clients in some of the toughest situations out there, from first-time offenses to serious felony charges. We've helped people protect their record, their families, and their freedom. So don't wait until it's too late. Visit mwpetersonlaw.com to schedule your consultation or call 617-295-7500. That's mwpetersonlaw.com and 617-295-7500. Because when your future's on the line, you deserve a legal team that's all in. Stay informed, stay legal. Now, back to the show.
I guess another question I'm sure people have is, if we have the marital home, how do you cut that in half? Like if I don't have the money to buy out my partner for 50% of the value of the home, assuming that it is genuinely marital property and there's not going to be some other complex math problem, half of it's hers, half of it's mine. If I don't have half the value of my house lying around, what happens?
So generally that's going to be a sale. So, I mean, if you have a house that you share and you decide, you want to live in the house, your spouse is going to move out, they're going to find an apartment, they're going to find their own house. Then they have two options. They can either buy you out, and if they don't have the money, it can be paid over time, but it depends on how much you trust your spouse with that. Or it could be a forced sale where you guys agree that we're going to sell the house and split the proceeds. And usually there's a court-appointed realtor or something like that who is neutral and independent, who can decide, what the house should sell for and things like that, because they don't want one side or the other to control it. And you also asked me about how things are divided, and I guess I forgot that part of the question, but it's not always 50-50. You can look at different things, like the big one is contribution. So if one side of the marriage was the one who contributed mostly to the earning of money and to the share of the household, essentially, then they can be considered for a larger portion than 50%. And also dissipation. So if, your spouse went out and spent hundreds of thousands of dollars on gambling or Beanie Babies, and you could say, hey, I want that hundreds of thousands of dollars they spent on Beanie Babies taken out of the marital estate. They already got that portion, and the judge can consider that as well. So there are a bunch of different factors. And like I said, this is just chapter headings. Obviously, there's a lot more involved here.
Right. And I mean, I'm going to definitely call you to account for throwing the word dissipation out there, because that's not a common word. So dissipation. No, and this, I think, is something I wanted to kind of tag, and I think this is a good time, so I don't want to ask you about it later. I think it's probably what is on a lot of people's minds when they're thinking about getting divorced, because I've talked to people about this, and it's, my spouse controls the finances. If I tell them I want a divorce, I'm going to end up on the street and penniless. They're just going to take all the money out of the joint account. They're going to lock up all of the credit cards or whatever. And so I won't have access to anything. And that's, I think, not an unreasonable fear. So I wonder it may be that this is a good chance for you to talk about automatic restraining orders, but it may also be a chance to explain what dissipation is. So I'll leave that up to you.
Yeah. Yeah, so an automatic restraining order is basically whenever you file a divorce, the rule is that you can't then change the way assets are managed or change or sell or encumber any assets. There are some exceptions to that, but basically it's to avoid the situation you're talking about. Like if I file for divorce and my spouse controls all the money and then all of a sudden I'm destitute and penniless and on the street, then that's not an equitable way to do things. And the law actually does its best to try to prevent that from happening, by saying if during the marriage your spouse paid the mortgage and the electric bill and all of that, they have to continue to pay those things. And also there can also be motions for temporary orders to get money out from your spouse during the divorce to pay for the divorce. So, attorney's fees and things like that. There is a fancy Latin term. I'm not sure how to pronounce it as a problem. It's like pendet lite, I think is how you, but that's what it means. I just know it's in italics. So that means,
it's Latin. It's probably Latin. That's a good guess anyway.
And you can get, and that's another exception to the automatic restraining orders, payment for counsel, because you don't want one side who earned the money to basically control the way the divorce is litigated. So there's some provisions for that in the law to prevent that exact situation.
Okay. So then dissipation.
Okay.
What happens if, during the divorce, somebody feels like they have to sell one of the cars or something like that? Or, how do you go about doing that without violating the automatic restraining order? Or because how do you avoid looking like you're dissipating or getting rid of the assets?
So yeah, dissipation just means the reduction of the value of the marital estate. So one way or another, the marital estate, let's say, is worth $1 million and you made it worth $800,000 through one way or another, selling things like that. So how do you avoid that? One is you have to get court permission. Is probably the simplest way to do it. Or you get a stipulation with your spouse. You say, hey, my sweet Chevelle that I've been restoring in my garage, I can't afford it during the divorce. I need to sell it. And you talk to your spouse about it, or the lawyers talk about it, and you agree to sell it and what's going to happen to the proceeds. Okay. Or if you can't agree, then the judge can decide it on a temporary order basis.
All right. So one of the things I think that ties into this, and I think is probably one of the harder things to discuss, is child custody. It's going to be, other than marital property, just having somewhere a roof over your head. This is kind of a difficult question, not just because it's a challenging one, I think, for people emotionally, but also because it really is probably legally a tough one. If you got a forced sale of a marital home, where do the kids go? Like what happens? How does the law provide for that? How does it attempt to provide for that?
Yeah, and so there are things in divorces that almost immediately happen called temporary orders, which governs how the divorce, what happens to the kids, what happens to the money, what happens to all of these things during the pendency of the divorce. So those are things that are litigated pretty early on in a contested divorce. So yeah, in the situation you're talking about where the marital home is gone, there would usually be temporary orders to determine who the kids are going to live with, where they're going to live, and things like that to determine what's in their best interest while the divorce is ongoing.
Okay, who decides what's in the kid's best interest?
The judge. Yeah.
Okay.
So yeah, the judge would, each side makes their argument. A lot of times this is one of the first hearings you have in a divorce is a temporary orders, is to determine who are the kids going to live with? Is there going to be child support one way or another? How are decisions going to be made about the kids? So who decides like what doctor they go to, what school they go to, what extracurricular activities they participate in? Those are all things that are decided in the temporary orders, usually maybe a month or two after the divorce, depending on when you can get a motion filed and get it marked for a hearing in the court. So
I kind of almost hesitate to ask what happens in the month where you're waiting for the temporary orders.
So that's an open question. A lot of times is before the court actually gets involved, then what happens? usually it's kind of decided between the parties. You can do an emergency, what they call a short order, an emergency in some courts, and try to get in sooner but it really has to be like, life or death. Somebody's going to be harmed if we don't do something about it now.
Okay. So, I mean, it's probably one of the reasons why the automatic orders kick in once the divorce is filed, right? There's certain things that it tries to provide for automatically, but it really can't plan for what happens to the kids because that's going to have to be decided specifically. So what I want to ask about custody, because people have heard the term custody. Everybody's heard that.
Right.
But what does it mean? And are there different kinds of custody? And how does that shake out?
So usually there are two types of custody. There's legal custody and physical custody. So legal custody means who gets to make the decisions involving the children. So if you have joint legal custody, that means that both of you kind of cooperate to make those decisions for the kids. If one party has sole legal custody, that means that the other side doesn't really have a say in it, right? So if I have sole legal custody and I want my kids to go to private school, then I can make that decision without the input of the other spouse. That's legal custody, is the ability to make decisions. Physical custody is who the kids live with. So generally there's going to be one party that has primary physical custody and the other party has parenting time. Usually the premise is 70-30 if you don't have primary physical custody. You can also have 50-50 custody, which there are a bunch of different provisions for that. Shared physical custody, week on, week off, these things get very complicated very quickly. As you know from drafting these agreements, when you're talking about different holidays, birthdays, all of that, and not to mention the regular week in and week out, custody can get very complicated very quickly.
Yeah, and it's one of the reasons you have to hash it out as much as you can in advance, because otherwise you're hoping that during a contentious divorce, you'll be able to come to some agreement about whether the children can be with you on your birthday when it's one of your off days. It's just not a fight you want to have, right? So it's one of the things that, again, you can do this yourself, but what if you haven't seen it before, certain things might creep up on you unexpectedly. What happens when there is joint legal custody, but there is a disagreement? Is that where a guardian ad litem comes in, or is it just going to be up to the judge? And is guardian ad litem a legal term that I shouldn't have used?
Ad litem is one of those italics terms.
Or Latin plaguing us in the legal profession. So, yeah, what is a guardian ad litem, and do they come in here?
So a guardian ad litem is and different states use this different ways. A guardian ad litem in Massachusetts is generally somebody appointed by the court to do an investigation and a report and make recommendations. So usually they're a lawyer. They'll interview everybody. They'll interview the kids, and they'll come out with a report that says, I think that mom should have custody, and here's the reasons why. It's not binding upon the court, but it is, pretty persuasive. If the sides agreed on this person to do an investigation and this person came to this conclusion. I forget what your initial question was.
When there's a disagreement on a legal division or a decision when there's joint legal custody. But I also wonder whether this has anything to do with if parties can't agree on primary custody, like who decides where the kids go. If I want primary physical custody, then what happens? If I think my spouse shouldn't have legal custody, how is that? Is that just something you need to petition the court for?
If you can't decide whether little Sally is going to do, ballet or gymnastics, and you and your spouse can't come together for a second to make that decision in the best interest of your kids, then the default is to go back to the judge about it. And I can tell you, judges, if you ever sat in a probate court, they go from 8:30 in the morning to 4:30 in the afternoon. And those judges are making dozens of decisions a day, and they do not want to decide whether it's in the best interest of your kid to do ballet or gymnastics. But that's a lot of times where it comes down to. And if the parties can't decide on something civilly, then the judge may say, okay, well, then one party gets to decide. And that's also where a well-drafted agreement can come into play. Where if you have a well-drafted agreement, like if there's a disagreement, here's what happens. And, you have a neutral third party decide, or you kind of alternate decisions, something like that, some process so that you don't have to involve the judge in every little thing.
Yeah. When can the child decide for themselves what happens?
So usually I mean, it depends on the child. It's not a age cutoff or anything like that. The judge will look at their maturity. The judge will, there'll likely be a GAL report that will sort of make a recommendation about when the child is mature enough to make those decisions. But usually we're talking about somebody who's a teenager or, a preteen, depending on what the decision is.
So the last thing I want to talk about when it comes to the kids is child support. How is that? I know it's probably a really big topic, so I don't know how you want to handle it in terms of headline points. But after that, my producer tells me we're jumping into a lightning round. We're just going to fire a couple questions at you. But I think we should cap off the talk about what happens to children in a divorce setting from a legal perspective anyway, with a good kind of condensed assessment of child support.
So child support is determined by the lawyer's worst enemy, which is math. There's there are guidelines that come out, and luckily for us, like the PDF, Adobe, whoever, I don't know what does it, but you put in the numbers and it spits out a number. So you say, here's what I make, here's what my spouse makes, here's where custody is. It's either one person has primary, the other person has primary, or they're shared. And it spits out a number based on what the guidelines say. Now, there are such things as deviation. So they can say, well, we want to go up and here's the reason why. Or we want to go down on child support and here's the reason why. But basically, it's a math equation. And you can play with the numbers as far as what numbers you put in there. But my income isn't really this, it's this, or I want this deviation up or down. But generally, it's going to be a math decision and if there's an argument about it, then the judge will make a decision based on that.
Yeah, I can't imagine how there'd be an argument about an upward departure from the guidelines that I should pay more child support than the calculator tells me. All right.
I mean, it's more common than you would think. My kid has special needs, or I have to take off work to take care of the kid more, so I'm not making as much money. It's basically anything under the sun that can potentially be a deviation. There are some very common arguments, but it's more common than you think that there are deviations one way or another.
Yeah, no, I'm not surprised about the deviation. I think what I wonder is if there's ever been a deviation anyone's agreed to, or if it's essentially always a fight. But, every case is different, right?
Oh, yeah.
So before we talk a little bit about alimony, which I think is a subject that's going to be important to a lot of people, we're going to shoot for what my producer is telling us we're calling the lightning round. And I think that to the extent you can give me yes or no or up or down answers on these, try to do that. And if you have to take the classic lawyer out of it depends, just do that instead. All right, are you ready?
I'll try to use a Latin phrase in every answer. How about that?
Oh, yeah. Well, bonus points if you can pull that one off. Should more people be using prenuptial agreements, or prenups as we call them?
So prenups are, I guess the short answer is yes. So more people should be using prenups. It's for very specific situations where there's a lot of marital assets, or a lot of things that you'd want to keep out of the marital estate. So if you have a large inheritance coming, or you have property, then you want to keep that out of the marital estate. And it's better to agree to that prior to you being in the middle of a divorce. But
right,
I would say that if there's special
shorter
issues,
and faster answers. Okay. So yes, more prenups. Is there such a thing as an ironclad prenup like we hear about on TV?
So prenups are so disfavored in the courts.
Probably that.
No.
Okay.
It is very easy to get around a prenup, especially one that's poorly drafted.
Love it. Mediation, overrated or underrated?
Underrated. It is so much cheaper to go with a mediator who's going to say, you're right about this, you're right about this. Let's settle this divorce, rather than fighting in court about it for years.
All right. What's more stressful for your clients in your experience when it comes to divorce? Is it questions of money or questions of parenting time?
Questions of parenting time, 100%. You can't replace that time with your kids. Right. We're both dads here, and we know that.
We were being light about this as to the best of our ability, but it really is a very heavy subject, and we can appreciate how difficult it is for people because we've had to lived through it with people who, professionally and personally. So we know how challenging it can be. Should the court consider a child's opinion in custody cases? You may have answered that a little bit already, but let's say it's not a teenager. Let's say it's like a child. Can they and should they consider it?
They generally do, and there will be like a probation investigation or a guardian ad litem, and the judge will take that into consideration. But at the end of the day, the judge has to make the decision about what's in the best interest of the kid. And sometimes, if a 6-year-old may just want to stay at dad's and eat junk food all the time, but that may not be in their best interest.
Fair. This one, I told you your answers could be yes, no, it depends. I'm going to give you pass if you want it. Do judges usually get it right when they're dividing property?
I think they try their best, and sometimes they get it right, sometimes they get it wrong. That's why we have appeals courts.
That's a good answer. What are the alimony guidelines? Where the alimony guidelines are something we're going to talk about in a little bit. Do you think they're too strict, too lenient, or just right?
I'm not sure what too strict and too lenient means in that situation. I mean, I think in every case, I feel like they can produce an unjust result depending on, but sometimes they're too high, sometimes they're too low. So I'll take it depends on that one.
All right. What if I can change it to, do the courts apply them in a manner that is too strict? Or are they pretty liberal in making adjustments where they think they need to?
So the judges in probate court have so much discretion, and they use that discretion. So I would say that if it's a situation where it just doesn't smell right to them, they generally are very good about saying, yeah, we're not going to go by exactly what the guidelines say, and here's why.
Okay. What's the one thing you wish every client knew on day one of getting started on a process like this?
I always tell people the only people happy after a contested divorce are the lawyers. Yeah, we get paid by the hour, and if you want to fight about it, then yeah. But at the end of the day, that's money coming out of your marital estate. That's money coming out of you. So I would say that before the emotions get involved, if you can come to a mediator, if you guys can come to a decision about the important things in the divorce, you save yourself so much time and headache.
Biggest mistake people make in custody battles?
I would say they get too focused on winning rather than what's in the kid's best interest. That's one thing judges can smell as somebody who is just after winning a divorce. They can see that this person, may not care about their kids as much as they care about winning and making their spouse miserable. So I would say that that's the biggest thing, is just act like a parent first.
It's good advice, but I think the unsaid part of your answer is if the judge can smell it, they're going to punish you for it, right?
Oh yeah, definitely.
Yeah.
If they can sniff it out, they're going to say, nope, yeah, you're after the wrong things here. Judges hate when people fight about this stuff. If people come to an agreement, that's the judge's best day. They always like, congratulations on coming to an agreement. You guys did such a great job. So when I'm sitting back there and I haven't come to an agreement, I feel kind of silly in divorce court.
What's one legal myth about divorce you hate hearing?
I would say we covered it earlier, but it's in my name, so it's mine, is one of the things that people just say all the time. And I have to correct them and say, no, it doesn't really matter whose name it's in. It matters how it should be divided.
Like when you got it. Yeah. Like when in the divorce. Again, feel free to take a pass on this last one. What's the first thing you'd do if you were getting divorced tomorrow? I don't know who wrote these questions, by the way. You got to talk to the producer about this one.
My wife watches this podcast, so I'm not going to answer that question. I'm going to pass.
I think that is 100% the right answer.
and not because I'm like trying to hide something from her, like trying to gain the edge. It's just, no, I haven't thought about that part of it.
Yeah. Let's move on then to a discussion of alimony. What is alimony?
So there are a bunch of different types of alimony. Basically, alimony is a cash payment from one party to another to basically try to ensure that their lifestyle remains the same post-divorce. Is usually the most common form of alimony. It can also be, so like the common situation is if you have spouse one who takes care of the kids and work so that spouse two can go get, we'll pick on doctors here, a medical degree. And that the spouse one, works and takes care of the kids while spouse 2 gets this profitable career. And at the end of the day, spouse 1 was held back in their career. They were disadvantaged at the end of the divorce, or when the divorce time comes around monetarily, so they can be compensated for that. So yeah, that's basically it, is a cash payment from one side to the other side to basically put them, to make sure their lifestyle doesn't change. Like, so it's a lot more common in longer term divorces or longer term marriages, and especially where one spouse has a lot more income than the other spouse.
Okay. What is the 2012 Alimony Reform Act?
So that really put a lot of guidelines, more specific guidelines about alimony into the law, about how long alimony can last based on the length of the marriage. So there's such thing as permanent alimony, which means that you have to pay it for the rest of your life, your spouse's life. And there's also term alimony that terminates after a certain period of time. And the 2012 Alimony Act basically formalized a lot of these guidelines for alimony, so that short-term marriages, you usually can't get longer, or you get a percentage of the time of the marriage. So like if it's 5 years, I think it's like 85% or something like that. I don't have the numbers off the top of my head, but basically there's a limit to the number of years of alimony you can get if it's a short-term marriage. And it also has the 35% difference calculation that's used as a guideline in these sorts of cases.
Okay, so then you used short and long-term kind of into it. Did the 2012 Alimony Reform Act give us a definition for that? Are you aware, or is it sort of a loose, like you just make the argument in court, this is a short-term divorce, it's a long-term divorce?
So 5 years is usually considered short-term. I mean, there are very specific things in the statute, like 5 years, 10 years, 15 years, and longer marriages. There are certain percentages of the years that you can have alimony for. I don't want to, like I said, math is kind of the lawyer's biggest enemy. This number is a close second. So you look at the statute and it'll tell you what the guidelines are on that.
All right. Oh, this is a tough one for folks. What is a financial statement in the context of a divorce?
So I've heard some lawyers say that financial statements is the heart of your divorce, and it really is, because a financial statement basically puts out your entire financial history in front of the judge, and the judge uses that to make decisions about your case. So how much you make, how much is deducted for certain things, how much you spend on certain things, how much is in your bank accounts. It's basically a complete picture of your finances. I see some people, like, their case gets called and they say, oh, you didn't fill out a financial statement. Here's one. Go in the hallway and fill it out, which is one of the worst mistakes you can make in a divorce, is to try to figure these things out on the fly when you're in the middle of a contentious situation. A financial statement is what the judge uses, and it's sworn under penalty of perjury. And actually, it's one of the only things that us as lawyers, we have to also sign. It's not under the penalties of perjury. I think it may actually be, but we have to say we have no reason to suspect that what is in my client's financial statement is not accurate. Because that's how.
So even if it's not perjury, you like lose your law license if you could be proven to have been misrepresenting it or lying.
Yeah, I mean, perjury
helping them, right? Yeah, you don't want to if you've helped your client hide money, financial statement will be a problem for you.
That's a white collar criminal defense lawyer here talking.
Yeah, somebody should definitely talk about money laundering at some point on this podcast for the better part of 2 hours. So. I think that, one of the things you talk about financial statements, and we've talked a lot about, how much money gets tied up in all this. Orders from courts, temporary orders, automatic orders. What happens when someone violates the order?
So that's called contempt. So you have it's actually kind of a separate complaint for contempt. You can file them during the divorce, after the divorce, all through. And in a lot of ways, a lot of courts hate them because they're so abused. Like, hey, he picked little Timmy up 5 minutes late, I'm going to go file a contempt. And they're also for important things too. Like, I'm not being involved in the decisions of my child, like the court order says. I need the judge's help. Basically, you will say this person is in contempt of this order. They're not abiding by this order, and the judge determines whether they're guilty or not guilty of contempt, and then what the penalty is for that. So in the case of parenting time, it could be make-up parenting time, or it could be you have to pay the other side's expenses for being late or whatever that may be.
Okay. So I think I know the answer to this, but I'd like to hear you talk about it. Can someone end up in serious legal trouble from contempt? And what does that look like?
I mean, so technically, contempt can include jail time. And if you look at a contempt summons, it says the penalty could be jail. I mean, it depends on the level of violation. It depends on what you mean by legal trouble. Sometimes a contempt can also involve criminal allegations, but generally we're talking about monetary or something that the judge is going to do in equity to sort of try to figure out the best solution to the issue.
Yeah, I mean, I was thinking specifically when I say legal trouble, again, as a former prosecutor, to me that means going to jail. But I do think, you touched on another point that I was thinking about this earlier, which was that if a person is found to have dissipated part of the marital estate, can the judge carve that out of what they get from the remainder of the marital estate?
Yeah. And that's a very common thing too. So if there's, if you say, hey, my wife's, sold whatever during the divorce, you can file a contempt. You can also address that at trial. And a lot of times these contempts, if they're situations like that aren't emergencies, don't have to be dealt with now. The judge can just reserve it for trial at the end of the day.
So that actually, I think, is a pretty good segue into the last thing I wanted to talk to you about, which is trials. You mentioned at the start that you and I are, by education and training and experience, we're trial attorneys. And that's not especially common in the divorce setting. We don't have to go into why that is, but I do kind of want to get the benefit of your experience in telling people again, high level, what does it look like? What does a divorce trial involve? Like, who's testifying? What is the evidence coming in? Like, even if you could start to finish, however you think would be the best way to describe this.
So it's in front of a judge. So it's what they call a bench trial instead of a jury trial. You don't have 12 people deciding this. It's a judge making the decision at the end of the day. Just like you see on TV, there can be sometimes opening statements, and then you go into the examination of witnesses. You call a witness, you do a direct examination, ask them questions, and then the other side gets to ask them questions. The rules of evidence apply. So a lot of times you see people who aren't trial attorneys, they don't deal with rules of evidence every day. They don't deal with objections every day. And they don't a lot of times know how to deal with that. So, but yeah, I mean, all of those things apply in a divorce trial. And the judge is the fact finder. The judge makes a decision about what happens to the different things at the end of the day. So if it's about child custody, the judge will say, here's what I think is in the children's best interest for custody. If it's about assets and dissipation and division, then the judge will make that decision at the end of the day to decide what happens to those assets. So that is what a trial is essentially about, but it works just like you see on TV. Witness gets up there and testify, including you. So like if you're a party in a divorce, then you get up there and testify, and there are exhibits, just like any other trial out there.
You ever have a trial where one side doesn't have a lawyer?
Oh yeah. And usually, so if you have a pro se person on the other side, then it's very difficult because you and I know what hearsay is. We know what leading question is. We know what the different objections we should make are. But somebody who is they may know everything there is to know about plumbing, but they don't know what it is to be a lawyer. So you're at a severe disadvantage if you don't have a lawyer going into that process, especially not a trial lawyer who knows how to keep evidence out. Because if you can keep a key piece of evidence out from that your spouse really wants to get in, that could be the difference in the divorce. That could be the difference in winning what you want out of the trial or not getting what you want out of the trial. So those sorts of things, it may seem like procedure, it may seem like technicalities, but that's the battleground. That's the way these things are won and lost.
Yeah. there's a couple of pieces. One, I'm going to ding you for using the word pro se, even though it's right. Pro se, always in italics, is a Latin term. PRO space SE. Don't ask me what it means in Latin, but it's when someone represents themselves in court. It happens in criminal court. It happens in divorce court. I'll tell you from my experience, just as messy in criminal court. If I was in legal trouble, I would not represent myself. It doesn't have as much to do in that sense with not knowing what you're doing, as there are like practical procedural reasons why it's a bad idea. Like one of the ones, I think we were talking about this the other day, if you have to testify and you are your own lawyer, you're basically just going to get up and start talking, and it's going to seem stilted and strange because it's basically just a speech. But I have had, and this is not a joke, people ask the judge, do I ask myself questions and then answer them? Like, should I do what's your name? My name's Jim. Look, we're laughing because we've been through this for so long, but for people who don't know, I mean, these are legitimate and serious questions. The other thing I wanted to kind of highlight about your answer is that is a great defense attorney answer and a great, seasoned trial attorney. If you can keep out a key piece of evidence, you absolutely should. But for people who are worried about what that might mean, there could be evidence that the rules are designed to protect against, right? So if your spouse has something that maybe they made up, but it looks kind of real, like it's not simply we should keep out things that look good for them. We should keep out things that may rightfully not belong in a courtroom. And if you don't know how to object to that, you don't know how to keep that out, that's going to come in and judge is going to look at that and going to say, wow, you spent how much at the racetrack? And it's like, I have no idea what that is. I've never seen that before in my life. And if you don't know how to attack it properly, you're basically just there slinging mud. And it's, I think that's, to me, the rules have that dual purpose of they can constrain you, but they also can protect you.
And there's all difference. All those come down from the common law and some 1400s or 700s in England. They decided hearsay and all of this sort of stuff. So they've been developed over the years for exactly what you're talking about. But there are also technicalities that lawyers will know the right words to say to get something in or to keep something out. And the trial I'm in the middle of right now, the other side is pro se. And I had said, you can just testify in the narrative, which is what we call, you can just say what you want. But I thought about for a second saying, no, you have to ask yourself questions. And I want you to stand at the podium when you ask a question and sit at the witness stand when you answer it.
Address yourself in the third person.
Right.
Yeah, no. And I mean, I'm not going to ding you for this one because I did the same thing, but hearsay it's been a legal term. Yeah. People might be familiar with what it is, but we could give you the textbook answer, but really what it means is, can someone just start repeating things they heard from other people? Like, Your Honor, our son said that he's a real jerk. And it's I don't think that, there are, that one maybe, I don't know, does that come in some exception or other? This is the other interesting thing, right? Even for lawyers who do this all the time, hearsay is something that gets argued in court before judges, right? It's not like simply knowing the rules is like playing a game of chess. Like, a lot of this is in flux. And you need to be able to argue exceptions. You need to be able to argue a lot of things that are difficult for people who do this for a living. And so if you wouldn't give yourself open heart surgery, consider whether it's a good idea to navigate a divorce by yourself. That's the way I look at it anyway. I mean, it's obviously not as bloody or severe, but the consequences can be pretty long lasting and damaging.
And just do a consultation. Like, just come to us. And if you're not sure whether you need a lawyer, you're not sure what the potential areas are, then we can sit down with you and say, here's where it's looking. You probably don't need a lawyer for that. I mean, I have that conversation a lot. Yeah, you probably don't need a lawyer for this after a consultation. So it doesn't hurt to talk to somebody and make sure that you have the right things in mind and you're on the right track.
Yeah, you're not getting ready to step on a landmine. Well, Matthew, this has been very helpful, I think very illuminating, and hopefully it's been interesting for the people who've been watching. I hope you will join us next time on another episode of Boston Barristers. Let's get back out there and enjoy that rainy day, Matthew.
Oh, yeah, definitely.
Thanks, Starting off. Yeah, thank you.